Hello, welcome to the Estate Planning under the Biden administration's tax plan, the Trust and Estate section, and the Elder Law Committee, and all of its webinars are generously sponsored by the Sanborn team, Geffen Real Estate, Glen Escrow, and the California Title Company. Brian Joy from the Sanborn team and Orit Gadesh from Geffen Real Estate are here to say a few words.
So I want to welcome everyone to 2021. Who would have ever thought last March, when this all began, we would still not be enjoying our monthly lunches at Lowry's? I know when this all began, we honestly thought we were all going to be out of business. But like the rest of you attending this meeting, this was not the case. This past year, we were able to face and meet all the challenges of selling real estate with COVID restrictions.
We've successfully navigated 10 court-confirmed sales and even had overbids. We've sold 11 multi-residential buildings, 15 single-family residences, and 2 condos, all during COVID.
As an aside, if you get an opportunity, please put your name in the drawing for a donation in your honor to the food bank. Last year, based on your input, we contributed to 3 of the LA food banks, the LA Regional Food Bank, Sovis, and Project Angel Food, And as always, we want to thank you for attending the meeting and supporting the Sanborn team. Don't forget, if you need us, we're always available to be a resource. Have a great meeting.
Now, Orit.
Hi, everyone. My name is Orit Gadesh with Geffen Real Estate. We specialize in both commercial and residential real estate sales. Over the past 15 years as the broker, I've developed best practices that serve my clients' best interests. One of the most important set of best practices I've written is related to pricing of properties. If you'd like me to email you a copy of these best practices, please text me at 323-606-1919. Hope you have a great rest of the week, and back to you, Megan.
Thanks, Orit. I appreciate it. And thanks, Nancy and Brian as well. Marcine Klein is a full-service escrow officer specializing in probate, trust sales, conservatorship, and both court and independent administration of Estate Act transactions. On a daily basis, Marcine works to ensure that even in the most challenging escrows close smoothly, and her clients are beyond happy with their experiences at Glen Escrow. California Title Company provides comprehensive and timely title insurance protection for homebuyers, including first-time homebuyers, sellers, veterans, and military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. For Manufacturers Bank, simplify your banking. Let Manufacturers Bank do it for you. Manufacturers Bank has a dedicated trust and estate banking team with the experience to handle all your banking needs. Contact Brian Flores, Vice President and Senior Relationship Manager, for more information. Just to have it on your radar, our next presentation will be on February 16th, and Matthew Burke will be giving a presentation on property tax changes, of which there will be a lot to discuss following the enactment of Prop 19. Now we'll have Beth Acevedo do the legal updates.
Thanks, Megan, and hi, everyone. I have 2 cases today, both conservatorship matters to discuss. The first is Conservatorship of Navarrete. It's a 4th District Court of Appeal case that was filed on December 4th, 2020. In this case, Anna Navarrete is a young woman with cerebral palsy, a developmental speech and language disorder, and has an anxiety adjustment disorder. Competing petitions for conservatorship were filed by her mother on the one hand and her father on the other. And at trial, multiple parties, including Anna's therapist, testified that Anna had told them that her father had sexually assaulted and raped her and that she feared her father. Anna's father denied these allegations. The trial court granted the mother's petition to be appointed Anna's conservator, but granted the father monitored visitation. The court concluded that it would be in Anna's best interest to have joint counseling sessions with her father to allow reconciliation in the event that the accusations of sexual assault and rape were untrue. Anna and her conservator objected to the visitation and appealed. The Court of Appeal reversed the trial court's ruling. The court stated that establishment of a conservatorship did not divest the conservatee of her autonomy and personal right to receive visitors, and that the public policy for maintaining a conservatee's personal agency as much as possible is so strong that the court may intervene on the conservatee's behalf to ensure that she can exercise those rights. The court stated that it does not have power to force an unwanted visitor on a conservatee, and that an adult conservatee's disability does not put her in a legal position of a minor, and thus the court may not compel visitation over the conservator and conservatee's objections. The second case is the Conservatorship of OB, which is a 2nd District Court of Appeal case filed in December 2nd, 2020. We actually discussed this case in August when it was before the California Supreme Court. As a reminder, in that case, limited co-conservators were appointed for OB, a young woman with an autism spectrum disorder. The appointment was made after a contested evidentiary hearing, and OB appealed the ruling on the ground that the evidence before the court was insufficient to justify appointment of limited co-conservators under the heightened clear and convincing standard of proof. The question on appeal was whether the appellate court must apply the same clear and convincing standard of proof when determining whether substantial evidence supported the probate court's judgment. The appellate court held that the heightened standard need not be applied on review, and the California Supreme Court disagreed and held that any ruling for which the standard of proof was clear and convincing standard must be evaluated on that same standard on appeal. On remand, the Court of Appeal reevaluated the evidence under the clarified standard and once again affirmed the probate court's decision. The Court of Appeal determined that the testimony of one witness may be sufficient to meet that standard, and it also noted that the trial court's observations of the conservatee contributed to the substantial evidence of the conservatee's lack of capacity. So that's it for our legal updates today. At this point, I'm going to turn things over to Andrew so he can introduce our speaker.
Good afternoon, everyone. It is my distinct pleasure to introduce our speaker today, Rob Strauss. Rob is a shareholder and director at Weinstock Manion, a law corporation, where he specializes in estate and wealth transfer planning for high net worth families, business owners, and real estate developers and investors. Rob applies his experience as a transactional attorney to develop creative and customized solutions that reduce estate taxes and achieve liability and creditor protection, and he advises business and real estate owners regarding business succession plans and pre-liquidity event wealth transfer plans. Rob attended undergrad at Harvard University before graduating magna cum laude with a degree in economics, before graduating from the UCLA School of Law. Beyond being a prominent estate planning attorney in Los Angeles, Rob is also a prolific speaker, as well as a teacher of advanced estate planning at UCLA Extension. As a quick programming note before we begin, please feel free to submit any questions you may have in writing via the chat or Q&A function in Zoom. We will collect these questions and we will ask some of them to Rob at the end of his presentation. And now I will turn it over to Rob to speak to us today about estate planning under the Biden administration's tax plan.
Thanks, Andrew. Thanks everybody. And Happy New Year. I think we all thought as 2020 was coming to an end that we would be leaving the worst year in history, maybe during our lifetimes, and starting 2021 in a much better place. It doesn't seem like it's starting in a much better place. Lots of problems, lots and lots of problems. And I note that most of us are incredibly busy as a consequence of, first, our concern that there was going to be a blue tsunami in November that would result in the immediate implementation of candidate Biden's estate tax proposals. And that didn't exactly materialize, but I'll talk about that in more depth. And lately, with dealing with Prop 19, it's great that Matthew Burke is coming to speak to the Beverly Hills Bar Association about property tax, but he's coming on February 16th, which is the day on which, or the day after which, Prop 19 becomes effective. And I have to tell you that we are up to our eyeballs in doing planning for our clients who have Prop 19 issues, who are rushing to transfer ownership of assets in order to take advantage of the rules that exist prior to the implementation of Prop 19. And we've never been busier. So thank you for being here, for pulling yourselves away from your incredibly busy desks in order to hear what I have to say. Hopefully what I have to say is interesting and useful. I'm not sure that it's going to be, but we're going to do our best. And I think the way to approach this is first to discuss what are the proposed changes. Then second, to try to evaluate whether any of it is likely to happen or not. And in that regard, I can only share, my own thoughts with a view to you developing your thoughts and then acting on your thoughts. And then finally, what we might do in order to plan prior to the implementation. So the Biden estate tax proposal is relatively straightforward. He has proposed reducing the exemption amount to just $3.5 million per person, down from its all-time high today of $11.7 million per person. It's a pretty major reduction. He's proposing to increase the estate tax rate for the value of assets in excess of the exemption from its current 40% up to 45%. And then third, and most interesting, perilous, perhaps unlikely of all, is the elimination of the step up in basis at death. I just can't even imagine that happening, but it's part of the proposal. So I guess the place to start is to evaluate, whether this could happen at all. And I want to start by admitting that I don't know anything. I really don't. And I've been wrong about a lot in my career, including back in 2012, when we were confronted with very, very, very similar situation, with the Democrats controlling both chambers of Congress and the presidency, with an exemption amount at $5 million, scheduled to fall at the end of the year to just $1 million. And we were absolutely convinced that it was going to fall, because why would the Democrats ever agree to not let it fall? And certainly there weren't votes anywhere to do any of that stuff, but it didn't fall. And so in 2013, I was giving speeches and I started by saying, estate planning attorneys must suffer from a failure of imagination because we couldn't imagine the exemption amount getting extended then. Well, so we were wrong then. And between the November election on the federal level and the January election in Georgia, I'd been saying to anybody who would listen, I really don't think that both Democrats are going to win the two Senate runoff races in Georgia. I really don't see it. And what was I saying that based on? Well, nothing really other than the polling. And I think we learned in the November election that polling is no science at all. It was off by prodigious amounts, at least 5% nationally. I think the last poll that we saw out of Wisconsin showed Biden leading by 15 points, and he won by 15,000 votes. I mean, it wasn't quite that close. So when the news was reporting that the races in Georgia were really close, I assumed that meant the Democrats were losing by 5%, and there was no chance that they were going to win. And of course, that was the first hurdle that would have to be overcome in order for there to be any chance at all that what Biden has proposed would actually come to pass. So the Democrats did win both of those seats, and the Democrats now have a so-called 50-vote majority because of the vice presidency. And the next question is whether the Democrats have the votes, to do anything in Congress. And I think that's really tricky to analyze. And I think the starting place to analyze that is the filibuster rule. So the Republicans were able to vote away the filibuster rule during the Trump administration and get done a lot of work. But they didn't vote it away on a permanent basis. The filibuster rule still exists. And it takes 60 votes in the Senate to overcome, which means Any legislation in the Senate, while the filibuster rule is in place, requires 60 votes. And where did those votes come from? I don't see 60 votes for any particular thing in the Senate. I could be wrong, of course. I mean, fundamentally, what I'm trying to do is show you how I think so that you can form your own opinion. And then based on your forming your own opinion, you can then advise clients, and then they have to form their own opinion, and then they have to react. Interestingly, though, I mean, really interestingly, about the 60 vote filibuster rule is I think it only takes 50 votes or 51 votes to get rid of the 60 vote filibuster rule. So the question then becomes whether the Democrats can find 50 votes plus the vice president to get rid of the filibuster rule. And I don't know the answer to that question. I will note that I think I read just last week or maybe the week before that Senator Manchin, a Democrat in a deeply, deeply red state, West Virginia, said he won't vote to get rid of the 60 vote filibuster rule. And if he doesn't, the question is whether there would be any Republican who would. I don't know the answer to that question. I really don't. I doubt that there would be a Republican who would. And this is just cynical politics. McConnell was really effective during the last 6 years of Obama's administration, saying no to everything. And the consequence of that was that the Democrats lost control of the Senate and lost control of the House and eventually lost the presidency. So why wouldn't he adopt a similar tactic? Why wouldn't he? Well, one reason he might not is because he historically has had a strong working relationship with Biden. I have no sense for how that plays out. I note that as part of the 2012 compromise that resulted in the exemption amount not falling, Biden was Obama's primary negotiator, and he wasn't able to get it done because the Republicans held all the cards. So they don't necessarily hold all the cards now, but I don't know how it would come out. So let's suppose that the Democrats could overcome the 50 votes that are necessary to do away with the 60 vote filibuster rule. So another pretty significant hurdle. The next thing is the Democrats would have to find 50 votes to implement this plan. And I think that's also going to be a challenge. And just note that there are blue dog senators, meaning Democratic senators from deeply red states. And Manchin is an example, but there's at least one other, forget his name, but there is at least one other. And it's not at all clear to me that a blue dog senator can vote lockstep with Democrats on any issue, let alone on a tax issue. Just not clear at all. Although I saw reporting today indicating that Manchin is supportive of the stimulus package and maybe supportive of the infrastructure package as well. But that doesn't mean that he's necessarily supportive of tax reform. So another hurdle to overcome is finding 50 votes to vote for this plan. So I was wrong about the Georgia election. I could be wrong about any of these steps. Maybe there are the votes to overcome the filibuster. And once that's overcome, maybe there are the votes to implement Biden's estate tax proposal. I don't know what to do about carryover basis, though, or stepped up basis. I really don't know. I mean, if that actually happens, on the one hand, a gigantic tax increase, seeming double taxation because of capital gains if the asset got sold too. On the other hand, maybe that would actually free up estate planners and therefore clients to engage in even more estate planning transfer work by gift and sale, because we're no longer worried about holding on to assets that have a low basis for the purpose of achieving a stepped up basis, maybe. So it's a lot of hurdles to overcome. As I was sleeping last night, Edwin Moses's name came to mind, the famous American hurdler who won all those medals and set all those world records. It would have to take an effort like that, I think, to overcome all these hurdles, but it's possible. It is definitely possible. And then the next question is, let's suppose Congress does pass this kind of legislation. When would it become effective? And there are 3 time periods, I think, that could be relevant. The first one is it could become effective when passed, and that's certainly possible. I would hope that we would have enough lead time about its deliberation and so forth, that we could try to do some planning for some clients. I don't know how much lead time we would have. I have no sense for that. But it is possible that that kind of legislation could be effective when passed. The second is it could become effective prospectively, meaning at some point in the future. Maybe the most logical time for that would be January 1st of 2022. I would love for that to be the case if this legislation passes, because that would give us time, hopefully, to actually do some planning. I have to tell you, speaking of time, that my personal group of clientele were so concerned about the projected blue tsunami that prior to the election, I had 49 clients reach out to me and say, we want to use our exemption amount now. And of course, we have to analyze each one of those. And it turned out that in each case, it was appropriate for that client to actually use the exemption amount. And when the blue tsunami didn't materialize immediately on election night or the week after, particularly because of the Georgia runoff election, of course, I reached out to all those clients and I asked them again, are you sure you want to do this? Because the composition of Congress isn't what the polling suggested that it would be, and so it may not be necessary. Interestingly, everybody but one said, yes, we do want to do it. The one who said no just last week called me and said, yeah, we do want to do it. Of course, there's new information in now, the Georgia election. Absolutely overwhelmed with work with just those, and more have come in since then. So I've got 56 of these projects going right now, 56 of these projects going right now. And that's like a third, no, that's like a quarter of my clientele who would need to do this kind of work if they wanted to in order to use the exemption. I don't know how we would possibly do that. And that's just me. Think about the rest of the folks at my firm, think about all of you. It's just an insane amount of work that would have to get done. I'm not excited about it. I remember giving a speech to this group a few years ago, explaining how tired I was from 2012, still just a few years ago. And it was several years afterwards, and lamenting that this might happen at some point, and here it is. So the third possibility for when the legislation might become effective, this is what everybody was afraid of, is retroactive to the beginning of this year. And of course, it's too late to do anything that would be retroactive to the beginning of this year unless it's already been done. I'm personally not so worried about that. I admit that it's possible, but I am unaware of any negative estate tax legislation that has ever been passed on a retroactive basis throughout history. And I think there's a good reason for that. I think it would be manifestly unfair. And the best example of how that would be viewed as unfair is this. Suppose somebody died today, and suppose there is estate tax legislation reform on April 1st, retroactive to January 1st of this year. Well, the person who died today would not have had an opportunity to reorganize her affairs in order to deal with the changed law because she is already dead. And I think it's because of that fundamental unfairness that there hasn't been any negative estate tax legislation ever that was imposed retroactively. Even when there was a discussion about, well, even when there was no estate tax and a step up in basis, that was not imposed retroactively. We were given a choice to opt in or to opt out. So, it's a little bit too late, as I say, to do anything effective as of January 1st, although some of you, I suppose, have gift trusts already in existence, and you may be able to effectuate transfers with private documents that are privately dated, but I can't advocate any of that. Nobody can advocate any of that. So I don't know what to do about that kind of thing. But there it is. I mean, those are a lot of hurdles to overcome, truly a lot of hurdles to overcome. I don't have a sense at all for how cooperative or conciliatory things will be in Congress. I don't think that the insurrection on January 6th made any of this easier. I think that it has driven an even deeper wedge in the political divide that we're confronting in this country. I don't know that it matters how the Democrats handle it or how the Republicans choose to handle it. I think that people have to sort out whether they want to have a democracy or something less than a democracy. And I realize that that statement in and of itself is a political statement. I mean, I'm not hiding that the fact that I'm a Democrat, but I have, of course, we all do, plenty of friends on the other side, and hopefully we can talk to them about issues in a calm, logical way without shooting each other like so many are dreaming of doing. All right, be that as it may. So if all this does come to pass, what do we do about it? And the short answer is, what we do about it is we use the exemption. And there are basically just two ways to use the exemption. And because there are two ways, there are probably three, which would be a hybrid approach of the two ways. The first way to use the exemption is simply to make gifts to kids or grandkids, just transfer assets away. Pretty straightforward. It's what we always do, transfer assets away. And we transfer assets directly, we transfer assets into gift trusts. Sometimes those gift trusts are generation skipping. Sometimes those gift trusts are intentionally defective grantor trusts for income tax purposes that also facilitate a sale. If we want to do, further wealth transferring beyond what can be gifted. I think you all know what intentionally defective grantor trusts are. I know that I've presented on this subject. I know that others have presented on this subject. I don't know that it's worth your while for me to dive into what those are, but if any of you want me to, let Andrew know and ask a question, and sure, I'm happy to address all of that. Basic idea though, very quickly. An intentionally defective grantor trust is a hybrid trust for tax purposes. For gift and estate tax purposes, the assets owned by that trust are not part of the grantor's taxable estate if the right grantor trust power has been selected. And if one allocates generation skipping exemption to that kind of trust, the assets in that trust also aren't part of the kid's taxable estate. It could be done in a state that doesn't have the rule against perpetuities, so it could last for 30 generations or 300 years, or if it's done in California, it would last 90 years or 3 or 4 generations, lives and being plus 21 years. But for income tax purposes, an intentionally defective grantor trust is treated as if it's the grantor, which I find really fascinating for a variety of reasons. One of which is, of course, the grantor pays the income tax. Every time the grantor does, that's the equivalent of a tax-free gift of the income tax that's paid and doesn't have to be reported anywhere. If there is loss or deduction, that still flows through to the grantor. It also means that the grantor can engage in a transaction with the grantor trust without any tax consequences. So the grantor can sell an asset to a grantor trust without any capital gains tax. Grantor could buy an asset from the grantor trust without any capital gains tax. Grantor could loan money to the grantor trust, and although the grantor trust would owe interest, there's no income tax on the interest. The grantor could borrow money from a grantor trust, and although the grantor would owe interest to the grantor trust, no income tax on that interest. And if the grantor trust owns an asset that the grantor is using, which would require the grantor to pay rent to the grantor trust for the right to use it, and it would have to be full fair market rent, that rent's not income taxable. So it's really, really flexible vehicle that allows for considerable wealth transfer planning, well beyond the making of mere gifts using the exemption. I say mere at a time when the exemption amounts 11.7 million, which means conceptually, parents acting together could transfer 23.4 million of assets into gift trusts and not pay any gift tax, all on a generation skipping exempt basis. And if those 23.4 million worth of assets had valuation discounts embedded within them, and there are all kinds of ways of generating valuation discounts. Maybe that's really the equivalent of 36 million of assets. If there were a 1/3 discount, that would be 24 million of assets. And it's eminently possible to achieve a 1/3 valuation discount. So that's a significant amount of wealth transfer that's possible through the use of intentionally defective grantor trusts. And then, of course, there was the basis issue, right? The assets that are transferred, and I know that there's at least one person in this meeting who doesn't necessarily agree with this, following Blottmacher's lead. But the assets inside of the intentionally defective grantor trust are not supposed to get a step up in basis when the grantor dies. I think we all know that, and I think that we all know that there's some literature that argues to the contrary, and I think we all know that there are some people who are taking the position that you actually could get a step up in basis. But if the Biden tax proposal passes and there isn't a step up in basis, I'm suggesting maybe we are left unconstrained with the idea of how to plan for reacquiring those assets from the IDGTs in order to deny owning them and getting a step up in basis, or the idea that when we're making our transfers by gift or sale, that we're focused on transferring higher basis assets so that the client can die owning the lower basis assets to get the stepped up basis at death. Maybe we're perfectly willing to transfer by gift and or sale lower basis assets as a consequence of that. But then again, politics comes into play, and maybe this is just what happens under Biden, and the pendulum swings right now from right to left. Maybe the pendulum swings from left to right, and the step up happens again, and the planning that we do during these 4 years or during this next period of time doesn't make any sense in a new regime, and I don't know how to deal with that. And we're all just thinking about it right now. Then I have a whole nother segment of my clientele who absolutely, positively, from any objective standard, could afford to make gifts. But of course, none of this is objective. It's all entirely subjective, and they think they can't afford it. It's just fascinating to me to get clients who are worth $100 million, $200 million, $300 million, whatever it is, or more, and they say we can't afford to gift 24 million, or with valuation discounts 35 or 36 million to our kids. We just can't afford it. Not we don't want to, not we're concerned about spoiling them, not we don't want them to know about it, or any of those other traditional reasons, but we can't afford it. And so for those clients, as we did in 2012, we're focused once again on spousal lifetime access trusts, SLATs. So SLATs are fundamentally, from a 60,000 foot perspective, basically the equivalent of intentionally defective grantor trusts that one spouse establishes for the benefit of the other. Basically, except they're not. They're a little bit different. They have to be different for at least two reasons. The first reason has to do with the reciprocal trust doctrine, and I'm sure most of you are aware of the reciprocal trust doctrine. I'd never heard of SLATs at the beginning of 2012. And of course, they became a really hot subject then. And we did a deep dive into the potential application of the reciprocal trust doctrine at that time, and discovered, as we had known already with respect to ILETs and the need to make a husband's ILET different from a wife's ILET for this reason, that there's a whole body of case law that suggests that one major difference between the two trusts, you have to decide what's major, is enough to prevent the IRS from succeeding in arguing that the trusts are mirror images of each other and therefore should be ignored. We're not comfortable, though, with just one major difference. At our shop, we're building in at least 3, sometimes 4, sometimes 5 major differences, just so that we're really comfortable, truly comfortable, that the IRS has very little shot at ever throwing out our SLATs based on the idea that they're mirror images of each other. And the differences that we've been building in would include, first, who the beneficiaries of the trusts are. So husband would create a SLAT for the benefit of wife, and in our formulation, and it doesn't have to be this way, you can choose how to do it yourself, wife would be the sole beneficiary of that trust. And if wife were also creating a SLAT for the benefit of husband, we would not have husband alone be the sole beneficiary. We would throw the kids in there too. So the first major difference is really a different set of beneficiaries. One of them we've got spouse plus kids, and the other one we have spouse alone. Second major difference would be the distribution standard. So what I've found is that in a typical husband and wife situation, and of course there are numerous exceptions, and there, no two cases are identical, the spousal unit is a little bit more concerned about the wife's feeling of ongoing economic and financial security, which is one of the reasons why she alone would be a beneficiary. And in that trust, we generally provide, not always, but generally provide that she must receive all of the income and has access to the principal, for HEMS. Whereas in husband's SLAT, and I call husband's SLAT where husband's the beneficiary along with kids, we make it discretionary with a HEMS standard. So we have mandatory distributions of income out of wife's SLAT, and we have discretionary distributions for husband and children out of husband's SLAT. And we might give husband a special power of appointment so he could push assets down to the kids if he wanted to during his lifetime, separate and apart from the ability to actually distribute income to them pursuant to the pot trust idea. Whereas we wouldn't grant wife a special power of appointment exercisable during her lifetime. So those are some pretty important differences. We would also try, usually, really hard when gifting assets to not gift the same assets in equal shares to the trusts. So for example, suppose they were doing planning with their principal residence. Your first reaction might be, well, put 50% of it in wife's SLAT and put 50% of it into husband's SLAT. I think that's allowed, but I think that that creates some risk that the IRS would argue, you haven't done anything. You both still own everything. So we try not to do that. We try to fund our SLATs with different assets into the two trusts, not 50% of each asset, but different assets, so that we take away from the IRS the opportunity to argue once again that the SLATs are mirror images of each other. So what's appealing to the clients about the idea of SLATs is that they're not giving the assets to their kids. They're basically using their exemption in a legal, valid, lawful way, but retaining cash flow. And what I say to clients is, look, if husband gifts assets into a trust for the benefit of wife and wife gets income, so long as they are married to each other and both living, wife's getting the income, husband's standing right next to each other. He's probably benefiting from the income that wife's getting. And the reverse would be true as well. And so while they're married to each other and both still alive, they both more or less have access to all the resources of both SLATs. And that's appealing to a lot of people. But I always explain that there's a divorce, it breaks down. The spouses absolutely positively walk away with their own SLATs. And then you have to worry about grantor trust status, because the SLAT that wife creates for the benefit of husband is an intentionally defective grantor trust, where wife is responsible for paying the income tax. And if there were a divorce, how does that work? And the reverse is true as well. Husband's creating a SLAT for the benefit of wife. It's a grantor trust. Husband's responsible for paying the income tax. But if there were a divorce, how does that work? And I've been through this process and tried to work out with family law counsel somehow the ability to continue to pay the income tax obligation. It's really challenging. It is fraught with difficulty. And in one of the cases that I had, we just realized that we couldn't figure it out in a way that would work and had to terminate grantor trust status, which as an estate planning attorney, drives me crazy, because of course I want to eke out every last benefit. But at the same time, have to recognize that my myopic view of the world is not shared by human beings. Human beings are thinking about all the issues that confront them, and in a divorce, it may be that you have to give something up in order for it to work. So that's an issue that you've got to talk to your clients about. And when they're happily married, it's kind of a fraught issue to raise, but the way I do it is the way we always do it. You simply say, look, I'm the lawyer. It's my job to bring these issues up, to discuss them. I'm not accusing you of having a bad marriage, but at the same time, if God forbid something happened, you need to know this. The second period of time when the SLAT concept breaks down is at death, because when one of the spouses dies, that spouse's SLAT goes to the kids. The kids become the beneficiaries. So the surviving spouse can no longer rely upon being able to enjoy the benefit of both slats plus the assets that aren't inside the slats. The surviving spouse will have to get by on just the one slat plus whatever assets weren't transferred into the slats. And I really do strongly encourage clients to think about what that means economically from the perspective of financial security. And of course, we all do that all the time with every transfer program we ever do. But remember, in this case, I think the concern is heightened because the clients have already said, we don't feel as if we can afford to give these assets to our kids. We're presenting the slat concept as an alternative to that. And so they've got to think through subjectively, whether they feel economic security after the first death. And for sure, I've had clients express concern about that. And so the answer might be, well, don't do this, or the answer might be, do it, but don't do it with all. And then I'll get a client who asks this question. Well, I know the exemption amount's 11.7 right now. What if we give, a portion of that, and then after the Biden administration's estate tax proposal passes, we'll just give the rest? Well, hang on there. Doesn't quite work that way. Suppose you have an $11.7 million exemption, and suppose you give $8 million today because you think you can afford to give $8 million, so that you have 3.7 left over. Well, what if the tax law passes? If the tax law passes and the exemption is now 3.5, don't you have 3.5 that you can still give? And I think the answer is no, because you've already given 8. So if you have an 11.7 exemption and you give away 2 million now, and then the Biden estate tax proposal passes and the exemption amount is reduced to 3.5, and you've already used 2, I think that means you still have 1.5 remaining. So it kind of doesn't make sense to give away 3.5 million or less if you're trying to rush to beat the implementation of the Biden estate tax proposal, because if it is passed, you'll always be able to give away 3.5. I think the rush or the concern would be to give away more. Then I've been thinking about slats a little bit further, and I haven't actually done this yet, but I'm on the verge of doing it with a handful of clients. After gifting assets into the slats, where the grantors are entitled to receive cash flow from the slats. In one case, right, in wife's, typically all the cash flow. In the other case, in husband's, discretionary income for hems. What if they were to do further transfers by sale? Couldn't they do that? Couldn't they enter into a transmutation agreement and allocate assets to husband and his separate property and other assets to wife as her separate property? And then the assets allocated to husband and his separate property, he could then sell to wife's trust, and wife's trust would have to pay him for it. And she could then sell to husband's trust, and husband's trust, husband's slat, would have to pay her for it. I mean, we do that all the time in connection with intentionally defective grantor trusts, right? It's a staple of our practice. Why couldn't we do the same thing with slats? And I think we can. I just haven't done it yet, principally because most of the time that we're using slats, it's because even objectively, the client perhaps couldn't afford to gift assets to the kids. But we do have these handful of much larger cases where, based on their own subjective experience, they can't afford to transfer assets to kids. So they're doing slats instead, but they have gigantic taxable estates. So wouldn't it make sense under those circumstances where they have gigantic taxable estates to consider selling assets to the slats? So I think, I'm afraid, I'm concerned that if this does come to pass, we're going to have an astonishing amount of work to do. And I can only hope and pray that we have enough time within which to help our clients. And the last thing ever I would want to do is say to an existing client of mine, I'm sorry, we can't help you. That would be just horrible, but I'm afraid it may come to that. And at the same time, I don't know how much outreach I should be doing to clients, because In order for the Biden estate tax proposal to pass, Edwin Moses has to win the Olympics, have to overcome all those hurdles. And, you know, it's possible because he did win the Olympics, set world records. It's possible. 47 something, I think. No, it was 43 something in the 400 hurdles. But I don't see it happening anytime soon. Again, I could be wrong about all that analysis. And you absolutely have to formulate your own views, and you have to figure out a way of explaining those views to clients, giving them a chance, I think, to formulate their own opinions, and then see if you can get them to take responsibility for making the decision about whether to take action or not take action. Because it's our job, and I see it as our job not to sell them on anything, but our job to explain, to teach, to inform, to put our clients in the best possible position to make good decisions. And in this environment, that is so challenging to do. And it's almost unfair, but I don't know what else we can do. We can't tell clients the exemption is going to fall because we don't know. We can't tell clients it's not going to fall because we don't know. All we can really tell them is this is what would have to happen for the exemption to fall. Do you think it's going to happen? Here's how I see it. What do you think? So with that, I understand that there are some questions. Let's see what those questions are, if I can answer them.
Thank you very much, Rob, for all of that. We do have just a few questions. The first one goes back to your original discussion of the chances of passage of any tax law. The question is, to what extent could the Senate pass estate tax legislation through the budget reconciliation process?
Sorry, I don't know how to answer that question. I'm actually not an expert on how things work in the Senate. I keep fantasizing about taking the time, for example, to research Manchin's voting record because I'm curious about that. But I've been so busy with client work and so exhausted from client work that I haven't taken the time to answer, and I do not know whether that this could happen through reconciliation.
Okay. The next one is, could you please comment on your thoughts about the chances of passage of valuation discount elimination, which we have been told is one of the legislative items the IRS has been pushing for?
Yeah, so right before Trump's election, legislation was brewing and percolating on this, right? And we saw draft legislation out of the IRS on the elimination of valuation discounts. And I read that legislation, I don't know, half a dozen times. And each time I knew less than the time before. I could not fathom what the words actually meant. I figured that somewhere in there, it meant an attempt to eliminate valuation discounts, but I honestly and truly did not understand what the words meant. Then I went to a whole bunch of programs, and Jonathan Lurie gave a really good program on this, and he tried to explain it, but he didn't really understand it. I had to give a speech right in the middle of this happening. I didn't understand it. And then Trump got elected, and the IRS put it on the back burner at his instructions. So wouldn't surprise me if this gets resurrected. But I hope that if it does, the IRS engages someone who knows how to write in English and understands how the tax laws actually work to put together a bill that is coherent and makes some sense that we can understand and figure out how to apply and perhaps circumvent. So it's definitely possible.
Next one is, could you address the Biden tax plan for tax-free exchanges?
Nope. Sorry, haven't read up on that at all. Not the subject of this lecture.
Yes, of course. And finally, the question we have so far is, what effect, if any, would an enacted Biden plan have on already ported DSUI from one's last deceased spouse? Would that DSUI be deemed vested and therefore cannot be affected by the Biden tax plan?
Yeah, I don't know the answer to that question because so far what I've seen is only at a policy level, not at a drill down into the weeds level. And I would think that that question would be answered by the specific words that are used. However, I would think that because there's an expectation in having carried that over, it would be my expectation that it would still be usable and valid and grandfathered under prior law. That would be my expectation, but I really don't know, and nobody knows until we actually see words on a page.
I think that's it for the questions that have been written. If anyone else has any more questions, I guess in the next minute or so, you can put them into the Q&A. If not, I think that's everything we have.
Thank you, everybody. Thank you, everybody. Thank you for your time. I appreciate it. I know how busy you are. I hope this has been a little bit helpful, maybe only a little bit. And I wish you good luck as you navigate through these changes, and good luck with Prop 19. We only have, 3 weeks left to put in place whatever we're going to put in place to deal with it.
All right. So thank you again to all our sponsors and to Rob Strauss for his presentation. For all of you wondering about CLE credit. Oh, hold on. It looks like we might have one more question before we go. Oh, we have one more of a statement that maybe you can, if you have any thoughts on it, just says Biden has proposed elimination of 1031, which is now limited to real estate. And there are new regulations about what constitutes real estate. Is that anything that's come across your desk?
No, it's not. It has not. Sorry.
Okay. So as I was saying, for all of you asking about CLE credit, for the lawyers, you will receive an email at some point, probably today after this presentation, giving you your CLE certificate. We did receive one question about CPA educational credit. Unfortunately, that's something you'll have to talk to your own regulatory boards, but we know at least for attorneys, CLE credit is available. So thank you again to everyone for coming, and thank you again for Rob for your presentation and all of our sponsors for helping to put this on.